I welcome you all to this inaugural A.K. Sen Memorial Lecture. It is going to be delivered by His Lordship Justice Surya Kant on the subject Advancing Justice through the Legal Services Act and the Constitution, Overcoming Barriers to the Legal Aid. One day, as it often happens in the Supreme Court, during a small break we all meet in the canteen. It was one of those days, Mr. Sanjeev Sen, Mr. Aruneshwar Gupta, Jitendra Sharma and me were chatting over a cup of tea, as we call it Chai Par Charcha. We discussed the topic, A.K. Sen is a big personality in the Supreme Court. Why don't we have a method to remember him and celebrate his memory of what he has done to us over a period of time? It was that discussion which brought us all of us together here. One day we together went to meet Justice Surya Kant and invited him to deliver the first lecture. He immediately agreed to us. Thank you, Justice Surya Kant, for agreeing and then to being with us. Then thereafter, Sanjeev Sen took initiative and he talked to Mahesh Jetmalani, Justice Indira Banerjee, former Judge of the Supreme Court, Justice Deepankar Datta, Judge of the Supreme Court, and requested Mr. R.G. Sengupta to moderate a discussion to start with. We will all start with a discussion on and about Mr. A.K. Sen, and for this purpose, I will invite R.G. Sengupta to come on stage along with Justice Indira Banerjee, Justice Deepankar Datta and Mr. Mahesh Jetmalani. After this discussion goes on for about 30 minutes, Mr. Sanjeev Sen, I'm sorry. The discussions take place for about 30 minutes. Thereafter, we will have the memorial lecture. Mr. Jitendra Sharma will conduct the program, and we will have on stage, apart from Jitendra Sharma, the Honorable Judge who will deliver the memorial lecture, and Mr. Aruneshwar Gupta, and also Mr. Sanjeev Sen. Sanjeev Sen is one person who will be sitting on stage throughout, and all others will come and go. With these few words of introduction, may I now invite R.G. Sengupta to take stage and then conduct the discussion. Thank you.
Thank you very much to the A.K. Sen Memorial Foundation, Mr. Sen, for inviting me to moderate this session. It's always lovely to see such a full house in memory of such a doyen of the bar, and it's wonderful that we can remember his legacy in this way. So thank you very much to the A.K. Sen Memorial Foundation on behalf of all young lawyers for doing this. A.K. Sen was a rare combination of erudition and effectiveness. He really was that archetype. And I remember one anecdote, and I'm sure there will be many, but since I have moderator's privilege. There was once when he was arguing very forcefully in court about a particular provision and arguing what its legislative intent was. And the judge asked him, "How could you be so sure, Mr. Sen?" And he said, "Because I drafted this provision." So that was Mr. Sen, a combination of erudition and effectiveness of a kind that the bar has rarely seen. Now, I am in the midst of stalwarts who know of Mr. Sen, have worked with Mr. Sen, and know his legacy very well. So I will not take much of your time. But we thought that the best way to honor Mr. Sen's legacy was to focus this panel discussion on the quest for rule of law in India. This is something that he strove towards all his life and his practice, and it is something that is still a work in progress. We know there is much work to be done in India to make us a rule of law state as the constitution envisages. So I'll start with you, Justice Datta. I wanted to ask you first about your reminiscences of Mr. Sen, both as a lawyer in the Calcutta Bar, as well as a judge, and now from the Supreme Court. If you could share some experiences.
Good evening, one and all. The question is such that I would have to disappoint Mr. Sengupta. I never had the occasion to work with Mr. Sen. I was a raw junior when I saw him once in the Calcutta High Court, in the corridors of the Calcutta High Court, arguing a matter. We knew that the gentleman was Mr. Sen, not only because of his legal prowess, but at the same time he was the law minister in the Indira Gandhi government and later on in the Rajiv Gandhi government. And the little that I can share with you is this, that what Nani Palkiwala was to Bombay, Mr. Sen was to Calcutta. And I was told by my seniors with whom I had the little occasion to discuss about Mr. Sen was about the phenomenal photographic memory of Mr. Sen. He used to cite judgments and then used to say, come to the right-hand side column, center of the page, you get the proposition that you are looking for. So I think
that Mr. Ashok Sen would be briefed in that matter. And I didn't believe it. I thought, how can you brief a senior at the last moment like that? Anyway, on the next day, I was pleasantly surprised, very excited that I had the opportunity to be his junior, and also very nervous that for the first time I was working with a senior of his stature. I went to explain the case to him. Now in those days, this was in the early 90s, it must have been in 91 or 92 latest. And you didn't have the computers, you couldn't get printouts for the asking. So there used to be, one engrossed paper, 2 or 3 copies, which used to be typed on the typewriters. There was 1 copy for the judge, 1 copy for Mr. Ashok Sen, 1 copy for the other side, but nothing for me. And I had drafted. When I went to explain the case to Mr. Sen, to my surprise, he knew all the facts on his fingertips. He must have got 15 minutes or so, or maybe less, to read the brief. He had picked out all the salient points. He just told me, "Young lady, please tell me the page numbers of the annexures." And I was in a fix, most embarrassed. Then he looked at me and he said, "Where is your brief, young lady?" I said, "I've not been given one." That saved the day for me. After that, I had the opportunity to work with him more often. But in that particular case, that was a writ petition seeking an interim order against the invocation of a letter of credit. Mr. Ashok Sen had all the cases on his fingertips. And he just said, "Get these cases from the Bar Library Club." This was Mr. Ashok Sen. There was another opportunity in an important matter. This was in 1993. Chambal Fertilizers was making its first offer of equity, the public shares. And one of the parties went to the Consumer Commission in Jaipur and managed to get an order of injunction restraining Chambal Fertilizers from issuing the equity shares. On that occasion also, a writ petition had to be drafted overnight. The point taken by Mr. Ashok Sen in his argument was later accepted by the Supreme Court and made the law. In your memory is not serving me right any longer, please correct me if I'm wrong. Morgan Stanley Mutual Fund versus Kartik Das, that the consumer forum had no power to pass an interim order. This, yes, 1994, yeah. This was what Mr. Ashok Sen had argued, and we had got an interim order straight away against the order passed by the commission, yes.
I'm sure there'll be more wonderful stories about Mr. Sen, particularly about his photographic memory, which is something that sort of lives on in the annals of the Calcutta High Court and the Supreme Court. I'll turn to you now, Mr. Jethmalani. As Justice Datta said, that what Nani Palkiwala was to Bombay, Ashok Sen was to Calcutta. And you, of course, practiced in Bombay. Your father, presumably, I'm presuming, knew him quite well, both former law ministers and of course, kind of personalities in their own right. So I wanted to ask you a specific question as a young lawyer. And since there are so many young lawyers in the room, what is it that we can learn from eminences like Nani Palkiwala and Ashok Sen?
No, I've got that. Thank you. Well, as far as Ashok Sen was concerned, my first brush with, I'm very lucky to have this brush with him, was in the Bombay High Court. I just returned from England. I was just enrolled at the bar in 1981. And we came up. I was assisting my father before a division bench for the Bombay High Court. And Ashok Sen had been brought by the central government. This was a period when he had, I think, 3 terms as a law minister. And this was one of the rare he was a parliamentarian at that time, but he was not law minister. And he came to the Bombay High Court to argue this matter. The question was a very interesting question. It concerned the prosecution of a former chief minister of Maharashtra for the cement scandal. The case was that Mr. Antole, A.R. Antole at that time, he had taken a quid pro quo for allotment of cement, which was a controlled commodity. And he was the head of the civil service, the civil ministry. And the question that arose, a very interesting question, was whether sanction to prosecute a chief minister could be given by the governor, because sanction to prosecute a chief minister or any public servant is by his appointing or dismissing authority. And the question was, is he bound on the question of sanction, the governor, who's his appointing or appointing or removing authority, is he bound by the advice of the cabinet, in this case the state cabinet, or does he have to act in his own independent discretion? And, I have to tell you that we thought we had a very good case, and we didn't know what the opposition would be. Mr. Ashok Sen actually, to his credit at that time, and he argued it so beautifully, he supported the case of the petitioners who were saying that the sanction had to be granted by the government acting in the exercise of his own independent discretion. And he said, yes, it would be absurd for any minister of the chief minister, any senior minister or any junior minister of his cabinet, to be the person who grants sanction to prosecute him. And he said, and this was his novelty at that time, he placed his arguments on the ground of the doctrine of necessity. He said, otherwise it would lead to an absurdity, that a man was being the sanction to prosecute for an accused person was being granted by either himself or a person who was subordinate to him and being a member of the cabinet. And he said the doctrine of necessity would come into play at that time, and the governor would have to decide the question of sanction in his own independent discretion. This was reported this is the Bombay High Court. I then had the good fortune, the matter traveled to the Supreme Court. Mr. Sen was very reluctant to appear because he had made this concession in written submissions, but he did appear at the Supreme Court, and the case was of course dismissed because the concession was recorded in some written submissions. He was asked to withdraw his concession which he made, and he went to Supreme Court, and he just glossed over the whole issue. And that decision today of the Supreme Court, 1982 Supreme Court, Justice Chennappa Reddy's decision, still holds sway. So I was his breadth, his advocacy was breathtaking. It was an object lesson in advocacy, and it was a real pleasure to hear him argue that case both in the Bombay High Court and in the Supreme Court. I also during those 2 cases, also learnt about his legendary love for rasgullas, which only his wife could prevent him, apparently, from devouring.
Living up to the stereotype of a good Bengali. So turning to Sanjeev now, you're perhaps best placed in this room to give us you had a real vantage point on Ashok Sen's life and career. So I'm not going to ask any more. Go for it.
Well, before I come to that, one little known fact is that, you see, Chief Justice B.P. Sinha offered Supreme Court judgeship to Law Minister Ashok Sen in 1960. Ashok Sen was 45 years old, and that would have meant that he would have been a Supreme Court judge for 20 years and Chief Justice for 10 years. And his tenure as a law minister was, in the initial period of time, was 1957 to 1966, in which amongst several other legislations, he introduced and in fact piloted the 17th Amendment, which relates to the power of the Parliament to amend the Constitution of India. But when he demitted office in 1966, immediately thereafter or soon thereafter, he appeared in the landmark case of Golaknath. Now, in the case of Golaknath, as some of my senior colleagues will recall, Mr. Ganguly will recall, that he argued exactly the same opposite of what he had actually piloted, and had argued that since right to property was a fundamental right, it could not be alienated by Parliament by way of amendment. In fact, a young Mr. Nariman, Fali Nariman, was engaged in that matter in Golaknath to assist Mr. Sen, and which experience he was later to describe was to mark a turning point in his career. Mr. Nariman describes the effortless reversal of roles by Mr. Sen and his extraordinary performance in the court. And since mid-60s till the end 80s, the law reports are full of all reported cases of all subjects and all branches of law. In fact, he was a master of every single branch of law, which is probably a very unique thing which one doesn't see anymore. And leading cases, I mean, it would take a long time to describe the leading cases, one of which was, of course, Royappa, which redefined Article 14, then Kraipak, which is considered as the Bible of natural justice. And as far as I'm concerned, as a law student, when I came to Delhi to study law and in the early years, I used to go to him every once in a while on a Friday evening. And I used to see him sitting in the corner of his drawing room with his notebook, with books strewn all around, and he used to make notes in his own hand in his longish notebook. And I used to ask him, "What are you doing?" He said, "I'm just updating my knowledge on not only the Indian law, but from all laws from all Commonwealth jurisdiction." It was actually a life of, he lived a life of, he devoted his life to law and the profession. And in fact, he had the largest library not only in India, but in the entire Commonwealth is what I'm told. Because he had reports from America, from London, England, New Zealand, South Africa, Australia, etc. As Mr. Jethmalani said, he had a great fondness for food, very discerning eater, and I have myself seen in his old age, after a full meal, having not less than 10 rasgullas and maybe 5-6 mangoes. Today, I don't think any of us would be able to have more than 1 or 2 mangoes after a full meal. He was a voracious reader. I mean, he was a great lover of movies and a devotee of Sri Aurobindo and Vivekananda. And when he went to England, he in fact participated in our freedom struggle. And therefore, my grandfather, who was ICS and who was India's first Chief Election Commissioner, had to guarantee to the British government that this young man would not create any mischief when he goes to England. And he was strictly, there was a guarantee given by my grandfather for him to behave himself in England. And anecdotes, as most of you know, I mean, he was very famous for his what is called corridor briefing. So when he was just on the way to a court, a magical ability to grasp a case in that short period of time and arguing the matter as if he had read the brief from top to bottom. One instance that one hears all the time is when Mr. Daftari was engaged in a very heavy matter and he fell very ill, and the judges would not adjourn the matter, and the matter was fixed for 2 o'clock. Mr. Sen was contacted at 1:45, and in 15 minutes he not only prepared the matter but argued so flawlessly that he continued and in fact succeeded in the case the next day. I mean, there are many instances like this. Our friend Mr. Janjani just told us 2-3 days back that he was arguing, who is here with us today. He was arguing a bail matter as a rank junior, and the honorable judge, after hearing the matter, threw the file and said, "You have nothing in your case." He did not know Mr. Sen. Mr. Sen got up from where he was sitting at the end of the court, and he came forward and started arguing the case and arguing for bail. And after some time, the file was taken back by the Honorable Judge, and in fact, he was ultimately granted bail. This was a story just narrated 2-3 days back. So these are kind of experiences, and anecdotes. I mean, he was a man of many myths. He was a legendary lawyer, and there are many, many stories. Some are false, some are exaggerated. But what is undisputed is that apart from being a legend in the profession, Mr. Sen had a persona and an aura that captivated and captured nearly all who came in contact with him.
Thank you very much, Sanjeev. I think there's a lot that young lawyers can certainly learn from someone, because he was really an encyclopedia in various, as in a huge gamut of areas. But I think a lot of senior advocates like yourself have also picked up this habit of corridor briefing from him. Now I know where that emanated. This seems to be something that...
to ask one question too, Sanjeev.
Yeah.
Which I know my father would have asked. Was that guarantee invoked finally?
I'm not sure that can be shared on stage. But one of the things that he's remembered for, and since we said that with this we are focusing this on the rule of law, is piloting the Legal Services Authorities Act 1987. Now, Justice Datto, you've had a chance to deal with that act, and you wanted to share an experience of a case that you dealt with, please.
About a decade back, while I was judge of the Calcutta High Court, a member of the scheduled caste community who was entitled to free legal aid approached me with a writ petition. His prayer was this, that look here, sir, I have been embroiled in litigation for the last 10 years. My property has been taken over by the secured creditor under the SARFAESI Act. I've been fighting litigation which has drained my financial resources. Ultimately, I have succeeded before the division bench, and the secured creditor has taken the matter to the Supreme Court. So I have been issued notice. I want to defend my case in person, but Supreme Court being Supreme Court, I may not be in a position to place my case as good as I wish to. So I approached the State Legal Services Authority with a request that I don't have money to go to Delhi to brief the lawyer. Why shouldn't the Legal Services Authority bear my travel expenses and accommodation expenses? So he filed a writ petition claiming a mandamus. Then I found him to be lacking in legal knowledge really, so I appointed an amicus. And the amicus argued very well, and then took me through the SOR, the definition of legal services, and I found legal services includes service of any kind. It is that wide and expansive. And I ultimately ruled that, Legal Services Authorities Act is not to only guarantee equality to people coming from marginalized section only on paper. It has to be made a reality. Otherwise, it would be largely a mirage that a person who wants to defend his case, he has no money, he cannot go to Delhi. In those times, there was no virtual mode available. So therefore, I felt that if a doctor is asked to treat a patient only on the basis of lab reports, would it be possible for him to treat properly? I felt no. He must clinically examine the patient. So therefore, here, if I apply this logic to this particular case, he may have something to say to the lawyer. Ultimately, we know the quality of lawyers that are engaged to defend those persons who are getting free legal aid. So therefore, this is one case where, it was one of its kind. I had opposition from everywhere, State Legal Services Authority, NALSA, Supreme Court Legal Services Authority, that we don't have the funds to bear his expenses. This was one of the grounds. Now, 10 years down the line, when I attend NALSA conferences, I find, my God, where does the money come from? 5, 6 judges from each high court are invited. We are accommodated in 5-star hotels. Is this the purpose for which the Legal Services Authorities Act was enacted? Is this the service which we are giving to the people who are really in need of legal aid?
I think this is really something for all of us to introspect, because the Legal Services Authorities Act was enacted with a lot of promise. And I think the right to free legal aid, of course, remains a right in the Constitution, for a fundamental right for every individual, but is not realized in letter or in spirit. And as far as the funding is concerned, I was looking at some data. As far as the funding is concerned, the funding of NALSA has gone up, but it's still a really minuscule portion of what we are talking about, because I saw an annual report from 3 years back, where the funding was only a small proportion of the funding for, say, digitization. And I think that there's a lot of work to be done. So Justice Banerjee, how do we try, in your experience, of course, the quest for rule of law in India, particularly through legal aid, is still an ongoing quest. And how do we try and ensure that this can be expedited so that justice reaches the most needy and deserving?
Those who are in charge of the legal authorities should have the will to perform and do something. A little while back, I saw Justice Dharmesh Sharma in this hall. He was the executive chairperson of the Delhi State Legal Services Authority when I was its executive chairperson as judge of Delhi High Court. Sorry, he was the member secretary. And a scheme was introduced to finance witnesses to give evidence in cases of atrocities against women. Many other schemes were also formulated during that time. So, there has to be a will to innovate. And what I used to do as chairperson of the Calcutta High Court Legal Services Committee, when I used to find a young lawyer doing well in my court, I would just stop and I would say, if you don't mind, I have a request. And when I said I had a request, the lawyer would just get flustered. So then I used to say, I have a request. Please get empaneled with the Calcutta High Court Legal Services Committee, and please do at least one case, maybe once in 6 months, once in 4 months, because these are lawyers with reasonably good practice. They would be earning good money elsewhere. So, some initiative has to be taken. Very unfortunately, I'll also point something else out. When I took over as the chairperson of the Calcutta High Court Legal Services Committee, to my utter surprise, I found the list contained the name of Dipankar Dotto, who had become judge I don't know how many years back. It had the name of Aniruddha Bose, who had become a judge 1 or 2 years after I did.
There are some people I think they didn't want to let go of.
Yeah, I suppose so.
Yes, please.
I have just one suggestion. There was a judgment of the Supreme Court in Supreme Court Advocates on Record Association in 2007, which deprecated the practice of the High Courts appointing retired judges as executive chairmen. And the Supreme Court said that only sitting judges should be executive chairman. If no one is available, then only you can go for the other option. What has been happening thereafter is that it is either the senior most puisne judge or the next senior most who is appointed as the executive chairman. And being senior judges, they are elevated within 6 months to 1 year. If anyone has any original thought or idea, that cannot be translated into action. So, as a piece of personal opinion, I would suggest that any judge who is fairly senior, but having at least the prospect of staying in his parent high court for at least 3 years, should be appointed as the executive chairman. Otherwise, there is no continuity. I was there for 4 months, my predecessor was there for 8 months, my successor was there for 1 month.
Was there for 9 months. Sorry.
9 months. So therefore, when I looked at the board, which had the names of executive chairman, the maximum was 1 year. That hardly fulfills the purpose.
That's right. And I think this does call for a rethink, because I just realized that the Legal Services Authorities Act came in 37 years after the Constitution, and we are having this discussion 37 years after the Legal Services Authorities Act came in.
We are only talking about the Legal Services Authorities Act. Don't forget the Income Tax Act.
Well, we'll hear.
We all pay income tax.
That's true.
And the Specific Relief Act.
That's true. That's true.
And many other laws, of course.
But I think we'll hear a lot more about the Legal Services Authorities Act from our chief guest and keynote speaker, Justice Surya Kant. So I'll end with a final question to Mahesh Jetmalani. Again, this is because of the fact that Mr. Sen was such an inspiration to so many young lawyers, particularly in Calcutta. And I remember growing up with stories that my father would tell me about Mr. Sen's illustrious career at the bar. So I wanted to ask you one specific question, which is that we live in an era of specialization, where everyone wants to be, as lawyers, more and more specialized, whether it is insolvency or data protection. And here was Mr. Sen, who was a generalist, if there ever was one, and an expert in multiple areas of law. So how do you think young lawyers in this age of specialization can channel some of that spirit of being kind of eclectic in your in their learning as well as in their practice?
Well, I started, by the way, Mr. Ashok Sen was not just, his fame was not just confined to Calcutta. He was, he was an all India legendary lawyer. I started my practice, primarily, my bread and butter was criminal law. But anytime I'd get a civil brief, I would grab it because I wanted to be a little more versatile. Also, I think what is missing these days, and is that trials are really taking place. The art of cross-examination has become a dead art. The Supreme Court now is releasing people on bail because they're being kept indefinitely with no scope of a trial even commencing, and that's absolutely fair. So I think, something needs to be done to expedite trials because, the real way you extract truth is through cross-examination, right? Particularly in gray areas, this is very important. Now, by the way, again, although Ashok Sen was not there when the Legal Services as Law Minister, between 1980 and 1984 and 1987, March, when he retired as law, he resigned as Law Minister. But all the work for the Legal Services Authority Act was done by him. It came in September, he resigned in March, so all the groundwork had been done by him. I have one suggestion. There was some talk about the quality of lawyers, and former Chief Justice Lalit in Karnataka gave a speech where he said, legal aid for the poor doesn't mean poor legal aid, right? I think it's time now that we make it mandatory. Look, the highest earners in this country, almost, individual earners, are senior counsel, particularly those practicing in the Supreme Court, and in the criminal law, yes, because criminals are willing to pay anything. Under trials are willing to pay anything. But it should be mandatory now for all senior advocates to do one trial, civil or criminal, and one appeal every year. It should be made mandatory because, don't forget, we have got ourselves exempted from GST on the ground that we don't perform a service. We are noblesse oblige. We are officers of the court and the dispensers of justice, or participants in the whole process of justice. So I think it is now mandatory for all senior lawyers to do one trial and one appeal every year. Otherwise, the government should say GST on you.
Well, true to the spirit of Mr. Sen, I think we've got many innovative suggestions for reforms. And I just saw the data. What we spend on legal aid, Justice Datta, is 190 crores per year, which was 2 years back, and which is 0.75 rupee. That's 0.75 paise per capita, which is an incredibly small amount if you think of it. We don't even spend 1 rupee per person, and 15 million people only have taken legal aid according to official stats for 33 years. So there is a lot of work to be done. I think in the spirit of Mr. Sen, we have gone over a vast area, starting from his personal life to actual reform suggestions for everybody to consider. And I think this has been a really insightful panel for me as a young lawyer, and I think it sets the stage perfectly for the next stage of proceedings. So I'll hand over.
Could I just add one thing?
Yes, please.
We've spoken about his legal acumen, his photographic memory. We've spoken about his corridor briefing. We've spoken about his love for food. And on one occasion, of course, when I was appearing as his junior, he first had the tiffin which was prepared by his wife. After that, he bought kebabs from Shashan. Then he bought rezella. Then he got rezella from 2 ladies who used to sell cooked food. While all this was happening, our matter got called on in court number 12, presided over by Justice U.C. Banerjee. So I appeared, I wanted to start, and I said I was being led by Ashok Sen. He said, "Are you sure he's going to come?" Because of his, reputation for getting briefed and whisked away somewhere else. And I kept on saying that he was there in the library. And it was very difficult to convince U.C. Banerjee. But more than that, I wanted to mention one thing. We have discussed everything, but I must say he was very kind to juniors who appeared with him. I had the occasion to attend conferences in his chamber as a very raw junior. On one particular occasion, the solicitor had not even told me about the conference. In court, he asked me why I had not attended the conference at his chamber. I fumbled. He realized, so he said, "The solicitor didn't tell you about the conference." Then he turned around. The solicitor was a senior partner of Khaitan and Company, Mr. R.N. Junjunwala. He turned around and said, "Niranjan, you didn't tell the only person who works about the conference in the chamber." And that definitely was a great thing at that point of time. Thank you.
Just to add, what I have been told is in the Supreme Court, the lunch that used to be provided by his wife was never consumed by him. It was always, sent off to the staff, and he used to always have very much more interesting and much more, spicier food. With that, may I invite Mr. Jitendra Mohan Sharma to please come on the dais and
I thought we were exiting.
This is Surya.
Good evening, everybody. On behalf of AK Sen Memorial Foundation, I welcome you all. May I request Aruneshwar Gupta and Sanjeev Sen to kindly escort Justice Surya. Honorable Justice Surya, Justice Rishikesh Roy, Justice Dipankar Gupta, Justice Koteshwar Singh, Judge Supreme Court, Mr. R. Venkat Ramani, Attorney General, Mr. Mahesh Jeshmarani, Senior Advocate, Justice Ramakrishna, I welcome Justice K.V. Vishnathan, Judge Supreme Court. As Santan told you at the very beginning, that over a cup of tea, we decided to have a name in memory of Mr. A.K. Sen. A.K. Sen I would not take much of the time about his briefing, because as a lawyer, you have heard about him a lot. And though we will be hearing about his achievements later, he belongs to an illustrious family in West Bengal. In Bengal, there were 3 brothers. One of the brothers, Sukumar Sen, whose grandson is Sanjeev Sen, and he is with us. The other brother, his son, Dr. Amartya Sen, is a Nobel laureate. So he belonged to a very illustrious family. After completing his education, he went to UK for a barrister. And thereafter, he started his practice in Calcutta High Court. Very soon, in the chambers of Justice Mr. A.S.R. Das, who later became the Chief Justice of Supreme Court of India. At a very young age, he was being asked, he established himself as a good lawyer. And then he wrote a book at the age of 26 years. However, apart from this as a lawyer, he has another aspect of his personality, the multifariousness of his personality. He was a great parliamentarian. He was elected for the first time in 1956, which he continued till 1977 as an MP in West Bengal, in Calcutta Northwest seat. Thereafter, he became a law minister, one of the youngest law minister in the cabinet in 1957. That was the Nehru cabinet. He had a distinction of being a law minister for 3 generations. First instinct was 57 to 66, and the second was from 84 to 87. Many achievements are there. Apart from this, he has a very much interest in Football Association, and he was a philanthropist also. Now coming to today's topic, May I now request Mr. Sanjeev Sen to give a introduction to the of our chief guest on the topic.
Justice Surya Kant was born on the 10th of February 1962 at Hisar, Haryana, in a middle-class family. He graduated from Government Postgraduate College, Hisar in 1981. He completed his bachelor's degree in law in 1984 from Maharishi Dayanand University, Rohtak. Justice Kant specializes in various extensions of law, including constitutional law, service law, and civil matters. He earned the distinction of being appointed as the youngest Advocate General of Haryana in the year 2000. He was designated as a senior advocate in March 2001. He held the office of the Advocate General Haryana till his elevation as a permanent judge of the Punjab and Haryana High Court on 9 January 2004. Justice Kant assumed charge of the office of the Chief Justice of the Court of Himachal Pradesh with effect from 5th October 2018 and was elevated as a judge of the Supreme Court of India on 24th May 2019. It is noteworthy that Justice Kant was nominated as a member of the governing body of the National Legal Services Authority for 2 consecutive terms. Justice Kant possesses a rare quality of seeing the human aspect in legal disputes, ensuring that justice is served with compassion. His judgments would often reflect a profound understanding of societal implication and the real life impact on the individuals affected by legal decisions. He has been a tireless advocate for access to justice, aiming to make legal processes more accessible and equitable for all. He has actively supported initiatives that promote legal aid programs, ensuring that even the most marginalized individuals have access to legal representation and a fair chance in the courtroom. By actively engaging with the legal aid organizations and encouraging pro bono efforts within the legal community, he has created an ecosystem to encourage a commitment to justice for all. While taking oath as the Chief Justice of Himachal Pradesh High Court, he emphasized that the biggest challenge before the judiciary was to provide speedy and effective justice. Justice Kant emphasized there should be a timeline in which every case should be decided and all stakeholders should work in furtherance of the cause so as to reach that destination. Underlining on providing swift justice to the poor and the needy, he said that the existence of the bar and bench would be meaningful only when they are able to wipe out the tears of the poor. Justice Surya Kant's impact extends beyond the courtroom. As an exceptional human being and a first-generation lawyer, he serves as an inspiration to aspiring legal professionals and the wider community. His commitment to fairness and the betterment of society serves as a guiding light for those who strive to make a positive difference through their legal careers. In the above introduction, 4 qualities emerge which are strikingly similar to the person we are remembering today. Firstly, mastery over all branches of law. Number 2, a very early success in his career. Number 3, a very keen interest in legal aid. And number 4, an inspiration to aspiring legal professionals. Justice Surya Kant.
My esteemed colleagues from the Supreme Court, Justice Rishikesh Roy, Justice Dipankar Datta, Justice Vishwanathan, Justice Koteshwar Singh, honored of the dais, most respected Sister Justice Indira Banerjee, former Judge Supreme Court of India, learned Attorney General of India, Justice Dinesh Sharma, Justice Dharmesh Sharma from the Delhi High Court, a very distinguished team of senior advocates, I would say led by Mr. Mahesh Jethmalani, and very distinguished senior advocates are here. It will take time if I will pay the individual respect to all of them. Mr. Sanjeev Sen, Mr. Aragya Sen Gupta, founder and director of Vidhi Center for Legal Policy, senior advocates and members of the Supreme Court Bar, legal luminaries, ladies and gentlemen. A very good evening to all of you. It's indeed my proud privilege to address you today as we gather here to commemorate the life and legacy of a man who has been hailed as an institution in himself. On this very first memorial lecture in the honor of Shri Ashok Sen, we reflect on his remarkable contributions as a distinguished legal mind, a true statesman, and above all, a compassionate human being who advanced the cause of empowering the unprivileged sections of the society. It is but natural that most of you will be very curious to know as to why I have been chosen to speak on Mr. A.K. Sen. Well, the simplest answer could be that such a large-than-life personality belonged to each and every one, and I am no exception. As a student of law, when we entered the profession or when we joined the bench, every day we used to hear about Mr. A.K. Sen's contribution. So it's very easy that anyone who belonged to the legal fraternity can speak about Mr. Sen. But personally speaking, I always have this special connect deep down. When Mr. Krishnan and Mr. Sanjeev Sen came to me, I put a caveat that I will speak. But then before I start speaking or saying my views on the contributions of Mr. Sen, I told them that you will have to bear me for 10 minutes, about 10 minutes, what I say about myself. They agreed, and that's why I also agreed. As they've explained, I was born in Haryana. Mr. A.K. Sen was born in district Faridpur, which is now in Bangladesh. So two remote corners. Despite this geographical expense, I must share that my 3 generations of my family share a deep emotional bond with Bengal and Bangla. And that is the reason that I was keen to speak. My great-grandfather was a Sanskrit scholar. When probably he was in the age group of 35 or 40, he was engaged to serve as a Sanskrit teacher in West Bengal, in Bengal at that time. He agreed and decided to go to an institute which was probably in Malda or near Malda. There was a resistance in the family, but he overcame and he decided he went there with a promise that I will return after 5 years. He didn't honor his commitment. Also started refusing to respond to the letters which my grandfather, his eldest son, would write. The family got really worried. Even they were worried that whether he is still alive or not. So my grandfather decided to go and trace out my great-grandfather. He went, found out his whereabouts, and with great resistance, he brought him back to the village. This is my father and my uncle, they narrated everything to me when I was a child. When he came back, he was a completely changed person. He would most of the time will speak in Bangla. His lifestyle was also of a typical Bengali. He would wear the dhoti and kurta, which I normally see my brother Dipankar sometimes wearing. And lot of, I would say, cultural infusion in my family took place after his arrival back. my grandfather was also fascinated by the learnings, I would say the wealth of knowledge which my great grandfather brought from Bengal. The most prominent example, I would say, of the cultural impact on my family was because of some renowned literary Bengali personalities whose books were made readily available to all the family members. And I know it's a long list, but just to save the time, the last personality among those literary figures included Mr. Surya Nirala, a very renowned poet who was born in Midnapur district of West Bengal, and a very renowned writer in Hindi as prose and poem both. How I could relate it was that Suryakant Tripathi Nirala probably was born on 21st February 1896. There was a dispute with regard to his date of birth, but he used to celebrate it on Basant Panchami, that it is the day my birthday. He died in October 1961. I was born less than 4 months in February 1962. I was also born on Basant Panchami. So my grandfather decided to name me as Suryakant. So I have been carrying this anxiety of that what is the correlation between me and Bengal. When I was a college student in 1979, first time family permitted me to travel beyond my state to the other parts of the country, but with a caveat that I must visit Bengal. So the first destination was Kharagpur, Asansol, Kharagpur, Calcutta, Howrah, and this is how, as a 17 years old student, I traveled most of the part of the Bengal. But then, as it happens, with the passage of time, my background was given. I belong to a middle class family. So the first anxiety was to build a career. But regardless of that, I must share with you another very important thing. My father told me that education, yes, of course, is priority. Getting merit is also a priority. But reading the literary books is also one of the most priority. So he gave me a series of books that I must read, and various authors within and outside the country. He persuaded me to read, and that was something that I really found by various Bengali literary figures. One of the most prominent among them who has really influenced in my, I would say, literary infusion was, of course, Sharchandra Da. His Bangla, his Hindi translation, and so many books I was able to, fortunately, to read it. But when I joined the profession, law, then struggle starts, and then you find yourself cut off the certain things because of the professional compulsions, and that you want to build up your own career. Till then, I was very actively involved in all the literary activities, and I used to be in touch with even those literary figures who were very well connected with Bangla and Bengali culture. At the age of 17 and 18, in fact, our literary club invited Mr. Vishnu Prabhakar, a Gyanpit Puruskar Vijeta, a literary figure who wrote a book, Avara Masiha, and that book was only on Sharchandra. So there used to be a debate at that time whether it's the biography or life discovery of Mr. Sharchandra or it's something fiction written. So we used to invite at that time. But anyway, when I joined the law and ultimately profession, the things were really, you get cut off, and then you concentrate more on profession to build your own career. At that time, one of my friend who was also a literary figure, he was a shair, then he wrote a letter to me that what has happened, that why I am cut off it. I also replied in a literary figure that there are the circumstances that you find yourself so preoccupied with profession and all these things that you get disconnected. But I have been having an anxiety that given a chance, I will revive and reconnect myself with Bangla and Bengal. let's coming to the theme of the day. Mr. Sen was a renowned personality, a stalwart. I think one of the two very simple instances I will share with you. Mr. Desai was his junior, and he presented a book to him. The name of the book was 6 Prominent Lawyers, and he wrote on it, presented to the 7th one. That was the professional stature of Mr. A.K. Sen. The subsequent publications would reveal that among the top 10 lawyers who have played the vital role in the history of this country, Mr. A.K. Sen name is figures. And those 10 names includes Mahatma Gandhi and Dr. Ambedkar. So he is considered and taken at that pedestal, at that level, among the top legal luminaries of the country. It was impressed by his legal acumen. Mr. Sanjeev Sen pointed out that Bidhan Chandra Roy, the first Chief Minister of West Bengal, recommended to the then Prime Minister, and on his recommendations, Mr. Sen contested and won the Lok Sabha election in 1957. And see, in that very year, he was inducted as the Union Law Minister. He served as Union Minister for 5 times, holding portfolios in communications, steel, and mines beside law. He remained Member Parliament from the seat till 1977, and then from 80 to 1987. And after that, he also was elevated as a member of the Rajya Sabha. When I was going through his political journey and career, I just reminded myself a famous शेर बशीर बदर साहब ने लिखा, हम भी दरिया हैं, हमें अपना हुनर मालूम है, जिस तरफ भी चल पड़ेंगे रास्ता हो जाएगा. He was that kind of personality. In 1966, he began practicing as a senior advocate in Supreme Court. And as you know, he was also president of the Supreme Court Bar Association 5 times probably, from 1973 to 1989. I think these are all rare distinctions that personality possessed. He was, as Mr. Sanjeev Sen explained, in Golaknath case, he led there in West Bengal versus Sopan Kumar Guha, where he argued to establish the principle of criminal law that no investigation can be initiated if the FIR does not disclose any offence. I think the concept of the power of 482, CRPC, etc., those were the principles first time were evolved in the matter which he argued. The anecdotes Mr. Sen Gupta has pointed out, and Mr. Sanjeev Sen has also pointed out some of the anecdotes. Mr. Sen is famous for that. But a few which one I recollect and I have been able to find out. When he was a Minister of Law, Mrs. Nazma Heptullah was the Deputy Chairperson of Rajya Sabha. And while speaking in the Rajya Sabha, Mr. Sen was addressing her time and again as sir. When Mrs. Heptullah reminded him that she was a woman and that the minister should address her as madam, Mr. Sen quickly came out with his banter and responded, and I quote, "Madam, you control the proceedings like a man, so I felt tempted to address you as sir." He was leading the debate on Terrorism and Disruptive Activities Prevention Bill 1985, and during the conversation, hot debates going on in Parliament, the same thing happened. He was addressing Madam Heptullah as sir, and then a question again arose that you are again addressing Madam as sir. This time Mr. Sen came out with another interesting story. He said, you know, I am recollecting one Justice Banerjee in Calcutta High Court. Because the debate does not contain the full name. So he said, I am recollecting Mr. Banerjee of Calcutta High Court. a young lawyer after post-independence, must be with socialist ideology, he stood up in his court and said, why we should not stop addressing Honorable Sir, you as my lords. This is all British culture and we should stop it. Just he spoke 5-6 times, then he continued that why we should not stop it, please give some reason. Justice Banerjee very politely said, look here, I don't mind if you address me even as a peon. But remember, my orders will still be binding on all the same. That was Mr. Sen's wit and humor and presence of mind that while addressing the House. One of the contribution of Mr. Sen was, of course, on Legal Aid and Legal Service Authority enactment, which my brother Justice Dipankar Dutta has explained, and Mr. rightly pointed out by Mr. Jethmalani that the act was formally launched in September 1987. But by that time, Dr. Hansraj Bhardwaj probably had taken over as the law minister. But there was a huge contribution by Mr. Sen in drafting and evolution of that idea, where the draftsmanship takes place and how this act is to be brought into force. I have some attachment with that act also. When I became judge in January 2004, I was just 3 years old judge. In 2007, it was exactly in February 2007, I got a call from the then Chief Justice of India, and he told me, young man, we are putting you in the governing body of the Central National Legal Service Authority, and because we need your services, you need to devote some time. There are various issues which the NALSA want to initiate, and for that purpose you come and meet me. So I rushed to Delhi. By that notification had come 23rd February 2007. I was appointed as member of the National Governing Body. You please recollect that only the executive chairpersons of the State Legal Service Authority are appointed in the governing body. Probably I was the first exception made. So I came and I was briefed that there are so many welfare schemes to be formulated by the NALSA, and for that this entire responsibility was required to be taken by me. I had the privilege of Justice Nageswara Rao at that time as a senior advocate and member of NALSA governing body, my sister Indu Malhotra as a senior advocate and member of the NALSA governing body. I think I worked with many of them, maybe Mr. Ganguly was also there. We had a team of all those who devoted time, formulated various schemes, and you will find from the NALSA Act that many of the schemes which NALSA ultimately launched are schemes of 2010. My first term expired from 2007 to 2009, but then again I was re-nominated and I continued in that capacity from 2007 to 2011. That gave me an opportunity to serve the cause of NALSA to the extent I could. That was another reason of my attachment with NALSA. There are good reasons which my brother has pointed out, that there is a lot of scope for taking some effective initiatives at the NALSA platform or the State Legal Service Authority platform to reach out to the common man, to reach out to the persons below poverty line, and we can do a lot. But when I was preparing my note for today's event, yesterday I was traveling, I came back, then I took liberty from Mr. Sanjeev Sen calling him in the evening that, can you forgive me if I don't confine myself to the issue of legal aid, and I can speak little more about other subjects also. He very happily agreed. Then I told that it will be completely unfair for me to represent before this audience, a distinguished team of legal mind, to say as if the contribution of Mr. Sen is only confined to the field of legal aid or the legal services. In fact, when you try to go through briefly to the long journey, legal journey he has traveled, you find his contribution in so many fields that it will take for me even to speak for months together, that if I try to speak on the illustrious contributions which he has made. But then I thought that some of the issues which really, where his contribution is immense, unparalleled, and which contribution is something like historical, I must try to briefly point out. The first thing I must say, Mr. Sen's contribution on the empowerment of the judiciary. And whatever I am saying is based upon the record and the documents and the well documented and authenticated records. Mr. Sen was an ardent supporter of the independence of judiciary in India and also strongly supported the empowerment of our constitutional courts. One of his major contributions to this effect was the enactment of the 15th Constitutional Amendment of 1963, where Article 226 of the Constitution was amended and Clause 1A was added, stating that the power conferred by Clause 1 to issue directions, orders or writs to any government authority or person may also be exercised by any High Court exercising jurisdiction in relation to the territories within which the cause of action, wholly or in part, arises for the exercise of such power. This clause first time, because before that there was a lot of anomalous situation with regard to the exercise of power by the High Courts under 226. And in a case where the part of the cause of action had arisen within A High Court, the other part in B, there were difficulties being experienced. So that was solved by Mr. Sen's note, and the entire amendment was in a way drafted by him, which ultimately took care of that impediment which the High Courts were facing for the exercise of their constitutional power. Another remarkable demonstration of Mr. Sen's commitment towards strengthening and preserving the independence of judiciary is when a private member bill seeking a constitutional amendment was moved in Parliament in 1963. The purpose of the bill was to restrict the powers of the Supreme Court and the High Courts in respect of entertaining disputes regarding election matters. This bill was vehemently opposed by Mr. Sen in Parliament, and what he said, I quote, "Sir, I have certainly given the best consideration to the bill and the amendment, but I feel that it would not be proper to take away the jurisdiction of the Supreme Court and of the High Courts." This was his last concluding remarks, that the bill failed and it was rejected by Parliament. What he said further, if we give the right of appeal to a litigant, it was in the context of election tribunal, if we give the right of appeal to a litigant to prefer an appeal to the High Court against the decision of the election tribunal, it is a logical consequence that we must provide for appeal and not take away the right of the appeal to the Supreme Court. He defended 136 like anything. That long debate, he speaks about the concept of 136, the philosophy behind 136, and ultimately defended. And this is how that act was rejected. Similarly, he launched and piloted the TADA Act and various amendments in that act. There also, with regard to constitution of the designated court, there was long debate that should the state government or the central government be empowered to constitute this court. It was Mr. Sen who insisted, said, yes, the state government, the central government may constitute, but it must be with the consultation, and initially the proposal was with consultation of the High Court. It was he who insisted that no, it must be with the concurrence of the High Court. Even with regard to consultation expression, what Mr. Sen spoke, I am just presenting before you. He said, consultation is a very known method of exercise of power. It means that do not do it without consulting those who are interested. You consult those who are vitally interested. That's all. Therefore, consultation is a condition precedent for any exercise of power. And we assented that amendment in the other house because we thought that the state government may be interested in saying that what it wants to say, where the courts are to be set up and how and all the rest of it. And then he says, the concurrence means the condition of High Court's prior assent will be mandatory for the state or the central government to establish these courts. That is how his vision was, that as far as judiciary's independence is concerned, that should be kept intact, be respected, and there should not be any legislative intervention to impede or to effect that power in any manner. Another very important field of his contribution was on women empowerment. 1963, the Dowry Prohibition Act of 1963. He is the law minister. And during deliberations on this legislation, see his very progressive approach and see his vision about the Indian society and how he realized the plight of the women folk in different sections irrespective of caste, creed or region, that how he realized that this is an issue on pan-India basis. When discussions were going on this bill, there were a lot of opposition of dowry provision. People were saying it amounts to interfering in religious affairs, it amounts to interfering in personal affairs, this and that. Lot of discussions were going on. There was a lady member parliament, Srimati Pushpalata Das. She was from Assam. My brother Rishikesh Roy belonged to that area. Koteswar is there. Pushpalata Das was from Assam, who very passionately highlighted the plight of tribal girls and correlated it to the story of how Guru Dronacharya refused to train children of lower castes, and then later, of course, he relented. She quoted Tagore's poem, which says, my brother and my respected sister will correct me, Bahu paricharya kori, peu chinu tore vats, gotra tab nahi jani. Then when the turn of Mr. Sen came to respond, well, there is a very long speech delivered by him in Parliament. There he equated the thought-provoking nature of this poem with the country's deep-rooted association of immortal womanhood, where women have always been considered as a comrade having equal rights. He was that the practice of dowry instead sought to degrade women and the ideal of women that have always been inherent in our culture. He then said, and I quote, the entire matter, which was at one time confined only to social reformers or to suffering parents, has now been highlighted in such a manner that it has been lifted almost to the level of a national problem. It has now reached what you might say the high water mark of caste. It has become a caste problem and not an untouchable any longer. Therefore, having been highlighted to this high level, it will now be for this Parliament gathered together and joined together with both the houses to pronounce ultimately upon this atrocious system and seal once and for all the legal existence of this vice. From now on, its existence will be illegal, clandestine existence against which the entire weight of law will be directed. It will no longer have that vitality to continue as it did have the olden days. And this is how he successfully piloted the act which was, the bill which was enacted as a law. You will also remember 1985 when the Supreme Court delivered the judgment in Shah Banu's case. The principle developed was equality before law and 125 CRPC provision. The Supreme Court said that it's religion neutral and therefore all the women, including the Muslim women, were entitled to maintenance under that provision. Now, Parliament at that time, whatever in its wisdom, they decided to replace that judicial dictum with a legislative mandate, and for that the Muslim Women Protection of Rights of Divorce Bill was introduced on 21st February 1986. Again, Mr. Sen was the law minister. The way the bill was put up and in such an articulated manner that it did not even remotely suggest that a judicial dictum was being replaced by a legislative mandate. He beautifully spoke on the vagaries of the concept of iddat in Muslim personal laws and stated, and I quote, our secularism does not mean that every man or woman must follow the same creed and faith in the same manner. The rich cultural heritage of this country, which has become part of our nation, has contributed its own life stream into the nation, and they follow their own creed and faith in their own way without interference. So this is how he piloted, gave a new dimension. When some parliamentarians wanted to oppose the aforesaid bill to the extent it granted maintenance beyond iddat period, that was the very hotly debated issue. Mr. Sen showcased utmost statesmanship and skill in not only underscoring his assertions but also in maneuvering his contention on introducing a right to maintenance for Muslim women by either silencing or convincing the other members of the parliament. And last what he said, that was something beautifully, as a statesmanship, that shows the leadership quality. Some parliamentarians, I know the names also, I have taken those names, they were shouting that no, it should be confined only to Iddat period. He said, please, we have heard you enough. This is not the way to understand the pulse of a community. No spirit of tolerance or patience is exhibited by such outbursts. So he knew how to snub also. Please have patience. It does not appear that you have studied the matter. All the issues will be unfolded when put the facts at the time of consideration. And he silenced everyone. The act was passed. Then in this very discussion, then he explained on the subsequent occasion on this very act. Then he explained this and he says, our secularism does not mean that every man or woman must follow the same creed and faith, as I explained to you. And then he explained that maintenance you can't confine only for the period. Maintenance is something which is attached to the life. It's a part of life and liberty. It's part of survival. And then he very passionately convinced the House and the act was passed. Mr. Sen, knowing the diversity that subsists in society, irrespective of what the decision on the enactment of such law may be, or without commenting on the way history unfolded, it was his modus operandi in consisting a very ably highlighting the women empowerment that is truly inspiring. Please see that 1963 and 1986 era, it was at that time that how he Dowry Prohibition Act or the I would say Maintenance Act in a new shape that he could successfully enact it. The other very important contribution of Mr. Sen is probity in life. When you go through his parliamentary journey and his commitment towards ensuring probity in public life, you will find that indeed he was really a conscious keeper of the democratic values. In order to build public trust and promote good governance, he took several initiatives to ensure that public officials act ethically and in the public interest. It is noteworthy that the concept of having a constitutional ombudsman to oversee functioning of public functionaries was first proposed by him in early 1960s. When today we have reshaped it as Lokpal and Lokayukt, this idea was first time invented or launched or projected by Mr. Sen way back in 1960. Then see his crucial role in the enactment of 52nd Constitutional Amendment in 1985, inserting the 10th schedule into the Constitution. He was the law minister. When this anti-defection law was tabled before the Parliament, see the statement of Mr. Sen. He says, and I quote, "The features which have appeared in the course of our development during the last 3.5 decades have exposed certain weaknesses in the working of our Constitution and of our legislatures, one of which is this phenomenon of defection which became more apparent from the 4th Lok Sabha, that is from 1967 onwards. It was an open secret that many people threw off their mental and their party labels and joined other parties for motives which were not always very admirable and in some cases quite questionable. We need not go into the details because they are sometimes sordid and sometimes unwelcome. But suffice it to say that this was frowned upon by every section of the public, by all reasonable and responsible legislators, everywhere, and by all political parties worth their name. It is felt that this must be curbed if proper and healthy functioning of our democratic system was to develop on lines which would be not merely a matter of pride, but would be a matter for admiration for the outside world." This is how very passionately he piloted the 10th schedule of the anti-defection law in the Constitution, which was successfully, of course, enacted at that time. Another extraordinary demonstration of Mr. Sen's farsightedness and pledge towards righteous cause in public life is reflected in his speech. Look at something, what a visionary he was. I am referring to a speech which he delivered on 3rd and 4th December 1970 as Dr. Rajendra Prasad Memorial Lecture. And Dr. L.M. Singhvi was the chairperson of the society which organized that lecture. And Dr. A.K. Sen spoke, you know what was the subject? Role of governors in the emerging pattern of center-state relations in India. That was the speech delivered. It's a remarkable speech. It's worth reading. I would request all of you to read. Whatever, you have seen subsequently some kind of strained relations in different parts of the country. I would like to commend Mr. Sen that he identified the emerging trends way back in 1970 itself. His suggestion on this issue hold true even today. And please see, I quote, "These are problems which assume importance for the purpose of considering how best it would be possible to create a body of conventions for the guidance of actions of the governors so that there may not be any conflict of a constitutional nature which may mar the smooth functioning of the governments in the states, either under the President's rule or without the President's rule." Mr. Sen further underscored the demarcation of the respective areas of functions of the constitutional authorities of governors and the state, and he said, "If there is a proper understanding and appreciation of the respective functions of each organ and office, there would be no conflict. Conflict arises only when there is either extra emphasis on the use of powers by one organ as against the other, or a tendency to create rivalries on the basis of party interest and politics." That was, this visionary spoke in 1970. This entire speech was published by Dr. L.M. Singhvi in 1975, though the speech was delivered in 1970. Mr. Sen was extraordinarily committed to the sovereignty and integrity of this country. What a strong viewpoint he had on this issue, I tried to find out. And when in support of 16th Amendment of the Constitution, Amendment Bill, when he was speaking in Parliament, he said, "We belong to that part of India," which he named one state, in the great poem of, beautifully explained, and how he was, that shows the articulation of the personality. He said, in the great poem of Tagore called Bhartiya, he said this, which if translated into English would read, "Arise, awake my soul on a pilgrimage to this great seashore of humanity, that is Bharat. Arise, awake my soul on the pilgrimage to the great seashore of humanity, that is Bharat." He says, "And this has mingled all races and all cultures, but today they cannot be discerned. They are all there and yet they are not there. It is a great sea of humanity, that is Bharat." At a later stage, he was again speaking when Article 19 was amended. The purpose of this amendment was to enable the state to impose restrictions for the purpose of preventing activities endangering the sovereignty and integrity of our country. To that effect, the amendment bill amended Article 19 to some provisions and inserted, "in the interest of the sovereignty and integrity of India, allowing the state to impose restrictions on these grounds." And then as a law minister, when he was presenting this bill, he said, very strong words, very, very strong words. He said, "I never heard that there was a fundamental right to destroy the unity and sovereignty of a country. Have we become so important? Has our democracy become so powerless that it cannot deal with people who challenge the very integrity of the country? I am sure the answer will be negative in firmest possible manner by this Parliament. Our democracy and our system of government are by no means powerless to meet such challenges in the name of fundamental rights. He was so strongly about that even in the name of fundamental rights, I will not permit this. Allaying the apprehension raised on behalf of, there was very genuine apprehension at that time felt by minority communities during the debate on this amendment. And you know what he said? With regard to the apprehensions mentioned, I have, I think, successfully or tried to successfully dispel these suspicions which minority groups might have held genuinely, and I would request them not to mix up the two things. If India survives, they survive. I think the Constitution makes enough provisions for the development and well-being of the minorities. But if India is destroyed, the minorities will be destroyed, along with others. Therefore, I would appeal to them, whatever grievances they may feel, genuine or not, have to be addressed in the proper way and not by challenging the very basis which sustains them as others. So that was, the man had very strong feelings and views on different aspects of the life, the country, the nation, the community, the probity in life. The other significant contribution by Mr. Sen toward the safety and integrity of the country as Minister of Law and Justice was when TADA Act Bill 1985 was presented. And then he said, the bill touches a very fundamental question as to whether our integrity, our unity, our democratic institutions, our federation or union, our system of government, the equality which it gives each man and woman, the rights which are given to every man and woman, and the great hopes which are enshrined in our directive principles are going to be destroyed by acts of men. That was the larger picture and canvas that ultimately he supported, and he successfully got the TADA Act amended. Most of my dear friends present here are from the legal fraternity, members of the legal profession. All of you know the contribution of Mr. Sen towards the enactment of the Advocates Act 1961. There also he wanted to, he very successfully launched the project at that time to convince the legal fraternity for the combination of the two acts of the Bar Council Act and the advocates, the regulatory measures for the advocates. The idea was again to control and to have the legislative measures for the conduct and ethical values of the lawyers. And there he spoke on the importance of the legal profession and how it need to be regulated by certain statutory authorities, the measures so that the public trust and faith in the system survives and enhanced. And for that, then he explained the importance and need of our at that time for the combination of the Bar Council issue and the Advocates Conduct issue. And this is how a combination of both the 1961 Act came into force. But all over and above, Mr. Sanjeev Sen also hinted about the humanitarian, the personal relationship of Mr. Sen. You know, one of the best quality I could see him, his respect for the parliamentarian colleagues, even to those who would criticize him left and right. And the best of the parliament debates, which I have been in recent times been able to read, is when on one hand Mr. Sen is speaking and on the other hand he is being criticized by Mr. H.N. Mukherjee, incidentally both belong from the Bengal. And the best of the intellectual debate you will find, and how they are respectful to each other, but at the same time because of their ideological or political differences, how they would be a very strong critic, but without crossing the Lakshman Rekha against each other. He was very helpful to junior members of the bar. There are several instances where he, as one of the instances was given, but I know, I have been told that there were several cases he would accept without any fee, and many a times he would argue the cases for the needy people without even charging the fee. That was his humane approach, that was his commitment to the cause of justice. In conclusion, I would say Mr. Sen's life stands as a testament to the highest ideals of the legal profession, a visionary lawyer, a skilled statesman, and a true gentleman of the bar. He shaped the legal landscape with wisdom, integrity, and an unwavering commitment to justice. Notably, he welcomed criticism with grace, using it as a tool for reflection and growth, a rare quality that further exemplified his strength of character. His legacy endures not only in the cases he argued or the reforms he championed, but in the example he set for generations to come. As we honor his memory, let's strive to carry forward his dedication to fairness, service, and the rule of law. I would like to appreciate and convey my regards to the dedicated efforts of all those involved in conceptualizing and the successful organization of this event to remember Shri A.K. Sen, the great man ever born in legal profession. Thank you very much. Jai Hind.
Thank you, Honorable Justice Surya. We are grateful to have so much insights of A.K. Sen. While most of us are well aware about his Justice Suryakant's professional journey, he started from a district court to the Judge Supreme Court and to be a Chief Justice. But to all my young friends who are in the beginning of their early years of profession, Justice Kant's life is an inspiration and is a living example which teaches us that through consistent hard work and commitment, sky is the limit. So now with this we conclude, and before we conclude, the organizers, the foundation had made some mementos to be remembered for this occasion. May I just May I just ask Rachna Shrivastava, Vice President, Supreme Court Bar Association. Rachna. To memento to Justice Suryakant, our chief guest. I'm coming. This. May I request Ms. Sonali Sen to present a memento to Justice Indira Banerjee. May I request Mr. Ujjwal Banerjee to present memento to Justice Dipankar Datta. May I request Sanjay Vashisht to present a memento to Mr. Mahesh Jetmalani. This function would not have been complete without Mr. R. Santan. May I request Akshat Sharma to present Mr. Santan Krishnan. Please. Okay. May I request Mr. Amrit Pradhan to present this memento to Mr. Sanjeev Sen. Come, Sanjeev. अभी May I request Ms. Anjali Singh to present a memento to Mr. R.K. Sen Gupta. Yeah, thankful R.K. Sen. I request Mr. Sandeep Singh to present a memento to Mr. Aruneshwar. Abhi, Sandeep Singh. And now with this, I request Mr. Aruneshwar Gupta to present a vote of thanks.
Just before the vote of thanks is given, I would request Mr. Devmalya Banerjee to come up on stage and give a memento to Mr. Jitendra Mohan Sharma.
Over to Aruneshwar.
Good evening, everyone, dignitaries on the dais and off the dais. Before I give my vote of thanks, I was amazed about this connection of Surya Kant Nirala and Justice Surya Kant. There's a very interesting connection also between Galileo, who expired in 42, and Newton, who was born in 1643, and then Newton and Michael Faraday, and Einstein, and finally Stephen Hawking, 1955. So this goes on and on. So there's a cosmic connection which happens, and this is very, very interesting. It is a privilege to stand before you as we conclude the inaugural A.K. Sen Memorial Lectures. First and foremost, I would like to extend my heartfelt gratitude to Honorable Justice Surya Kant for delivering such a captivating and insightful lecture. His personal anecdotes about Mr. A.K. Sen were not only enlightening, but also befitting tribute to a towering figure in Indian law. We are deeply grateful for his time and wisdom. I would like to express my sincere thanks to Justice Dipankar Dutt, Justice Indira Banerjee, Mahesh Jethmalani for contributing to such an engaging and thought-provoking interactive session. A special thank to R.K. Sen Gupta for moderating the session so seamlessly, helping guide the conversation in a way that truly honored Mr. Sen's legacy. On a personal note, I hold dear memories of Mr. A.K. Sen. I vividly recall his visit in 1968 and having lunch at our place when a matter was being argued in Jodhpur. My father was a lawyer then, before he was elevated as a judge in 73 and retired in 86. And his love for food was, everybody has talked about it. He always enjoyed good food. From the moment I began my practice in Supreme Court in 1976, I had the honor of briefing Mr. Sen on several occasions. Working with him was always a pleasure. His simplicity, humility, and depth of understanding of the law was remarkable. One could not help but admire his exceptional memory. We already talked about it. He could recall the exact page numbers and the briefs he had previously argued, and the opinions that he had given. He would say, Aruneshwar, look at such page, we are given that judgment. I particularly remember one instance in 1983, when I received a call at 8:20 in the morning from another senior, whom I have briefed in 3 SLPs listed on that date. Adjournment was no ground. for a senior's non-availability. I phoned Mr. A.K. Sen, and with that characteristic calmness, he replied, "What is the driving time?" He was residing in 19 Tirumurti Lane, and I was in Greater Kailash 1. I responded 20 minutes. I was at the residence at 9 a.m. and we had concluded the conference. He appeared. He always used to say, "Aruneshwar, 3 minutes." And that was all the time I needed to convey the core issue to him. In those few minutes, he grasped the essence, and everything beyond that was blah, blah, blah. In 1995, when I was secretary to Supreme Court Bar Association and organized the Meet a Lawman series, we had a privilege of having Mr. A.K. Sen, Justice J.S. Verma, address the bar. During his remarks, Justice Verma shared that he had learned so much from Mr. A.K. Sen while sitting on the bench. He humbly added that he had no hesitation in admitting that he was still in shorts when Mr. A.K. Sen was already a senior advocate. This acknowledgement spoke volumes about the deep respect and admiration Justice Verma held for Mr. Sen, vast legal acumen and experience. Mr. A.K. Sen's ability to cut through the chaff and focus on the crux of the matter was truly extraordinary. With remarkable clarity and insight, he had an unmatched knack of distilling complex issues down to their core. His demeanor was always one of humility and yet quite authority. His speech was impeccable and articulate, each word delivered with clarity and precision, making even the most complex point accessible and easily understood. He commanded deep respect from judges, who valued not only his legal acumen, but also his dignified, respectful, and composed manner in court. I extend my deepest gratitude to all the speakers and participants who shared their experiences and expertise today. Your presence has truly enriched the event and made it a memorable occasion. Finally, my special thanks to AK Memorial Foundation for their vision and dedicated to keeping the AK Sen legacy alive. Thanks to LiveLaw for supporting the occasion. This event is a testament of their efforts, and we are all fortunate to witness and participate it. Thank you, each and every one of you, for being the part of today's lecture. Your presence underscores the enduring impact of Shri A.K. Sen's work and his contribution to the legal profession. Thank you once again. I wish you a wonderful evening. Thank you.